Right, we'll just give it another minute just because we're just waiting for the speaker who's just gone to get a quick glass of water. Perfect. So I think we'll start if that's okay. Hi, everybody. My name is Dr. Reem Pervez. I am a GP partner at Rugby Medical Centre, but I'm here as an LMC board member. Today, just to let you know, this will be recorded so that we can share it with those individuals who aren't able to attend. If I can ask you all to mute, we'll do some questions at the end, but if you've got questions, pop them in the chat in between and I'll bring them up to Daphne as we sort of go on. So today we've been joined by Daphne Robertson from DR Solicitors, or Doctor Solicitors. Apparently, the two go hand in hand, and they're a team based in Guildford, essentially. They represent GPs, dentists, consultants, and primary care. And today we're discussing kind of partnership agreements. So Daphne, if it's okay with you, I'll hand over to you.
Super, thank you very much. Right, can I just double check? Can you see my slide deck? Excellent. Thanks for the thumbs up, Charlotte and Rima. That's great. So welcome, everyone. As I've been introduced, my name's Daphne Robertson. I'm the senior partner and founder of DR Solicitors. We've actually got two offices now, Guildford in Surrey and Manchester. So well placed, largely because we act nationally across the country. That's important because this is just a list of services that we offer. And it's important because what I'm seeing now is two things. It's not just all about partnership agreements and the odd conveyance or lease. Practices are scaling up, and that's happening very quickly, and they are integrating with other services horizontally. So there's both scale and integration going on. The one thing I would like to say to you is get the structuring model right at the start. What we're seeing is as practices are scaling up, they are doing it in a very fluid, informal way, and it's ending up in a bit of a muddle if you haven't got your partnership deed documentation properly crafted, because it's critical business documentation. That red box at the top enables you to avoid that nasty blue box at the bottom, which is where you land yourself if you're in dispute territory. The costs of actually getting legal documentation in place are relatively small in comparison to the costs of resolving disputes. And that's why I'm here today, to try and enable us to get over the line in terms of understanding what we mean about partnerships, what it means to be in partnership, what other models are out there, and top tips in terms of traps to avoid, because they can be very unpleasant. So without further ado, with Charlotte and Mira's assistance, I've basically come up with this agenda for today. There's actually quite a lot to fit in, and I really appreciate you putting your lunchtime aside today, given it's also hot and it's a busy time in general practice. That's without a shadow of a doubt. There's quite a lot to cover. I wanted to cover the partnership model. Lots of confusion around it, and I want to clarify that confusion so we're all clear on where we are and the landscape that we're sitting in. And then I want to cover off surgery premises, because the two key assets of any general practice are the GMS, PMS, APMS contracts and other local contracts that you may own, and then the surgery premises, whether they are leasehold or freehold. So And do please ask questions as we're going along. It's a nice informal group. I'm very happy for you to interrupt. If it's something that I think I'm going to be answering later on, I'll say so. And Mira and Charlotte are going to keep an eye on the chat. So I always think whether you are already a partner or you are thinking of becoming a partner, or you are a business manager managing a group of partners, whether those partners are clinical or non-clinical, I think it's always useful to remind yourself about why you might want to become a partner, or why the partners you are managing are partners, or if you are a partner already, does this all chime with you? Because it isn't just when you're managing a business. I'm a business owner. You don't just go home at night and forget about everything. It pervades all aspects of your life, basically. And you are managing a highly regulated business, and you're a responsible business owner. So if you haven't got direction, some kind of control over the direction of travel in which the business is going, you should be asking yourself, what are you doing? Because that's part of the profits that you earn versus the risk of being in a joint and several liability partnership. You've got control over the direction of travel of the business. Obviously, you share in the profits and losses. Yes, you get the title of partner. That's always not obvious from the website, actually. Lots of GP practice websites are out of date and don't necessarily say who's a GP partner or not, but you're on the letterhead. You've got increased responsibility because you don't just turn up, do your sessions and go home, and the paperwork and the admin is dealt with by someone else, and the obvious tax advantages. But I always think it's helpful just to keep a grip on why you might want to become one. And then if you are one or you're thinking of becoming one, I think this is an aid memoir as to what to be asking yourself. I think it's a disaster to just be taking on a partner because you want some succession planning, and that is all there is to it, and everyone's going to be a fixed share partner, and you've got a couple of equity partners with fixed share partners. You've got to be thinking, are you trusting one another, not just because they're the only person that applied for the position? It's got to be someone that you feel is able to manage the business with you. So I hope you can say yes to all of those questions. I think that bottom blue bullet is really important, because in general practice, there isn't enough due diligence done. You see people joining practices with huge invoices from CHP or NHSPS, for instance, and where does the liability for that sit? You see people joining practices where there's a dispute in the middle, and then starting to pick up the costs of that. So make sure you've done your due diligence. And if there are liabilities, it's not like you can just magic them away. You just make sure that the liabilities and risks are minimal for you and they're sitting with someone else, hopefully outside of the practice and covered by insurances, but we'll come on to that later. I think, can I also work alongside the other partners as an equal is an important one. A couple of years back, I got presented with a partnership deed, which was a dispensing practice, and the GMS income was split fairly. Then the schedule at the back said that the dispensing income was split 90% to some of the partners and 10% to the partner that was joining. And actually we got that completely reversed, because of course dispensing income is part of GMS, and why should it be split differently from the GMS? Ultimately, as a joint and several liability partnership, you're responsible down to the sole of your shoe for all the debts and liabilities in the business, not just 10% of them, for instance. And I would add that the joint and several liability partnership model is interesting. It has worked since the inception of the NHS back in the 40s. It's worked well because it's a very flat, informal structure. You can really easily change your working sessions that you're allocated and your profit shares. You can change the way you run your business really easily. It's not like a limited company where you've got to have board minutes, submissions to Companies House. The same with an LLP, limited liability partnership. Incidentally, you cannot be an LLP and own a GMS contract at the moment, but I do know there is agitation for that going forward. So it wouldn't surprise me if at some stage over the course of the next few years, there is a change in statute over that to allow you to be LLPs. But the only other working group of people that use joint and several liability partnerships to the extent that they are used in general practice are agricultural farmers. And they are mostly families. So that will give you an indication, and they also have the most terrible disputes. So that will give you an indication as to why it works. It's a very flat, informal structure. This is my memoir of things to look out when you're doing your due diligence for the practice. As I've said, I don't think enough people do enough DD. And I think included in that is, are you going to be serving out a mutual assessment period? That's really important, because if you're going to serve notice where you are in whatever capacity, give up your employment rights to become a self-employed partner or move from one practice to another practice, you've got to have certainty over what are the terms of you joining. When you join, are you being expected to buy into the building? If so, at what value, or multiple buildings? Or are you expected to go onto the lease or multiple leases? So what are the terms of any mutual assessment period, if indeed you're serving one out? Many times these days, people have already worked as a salary GP, so they're not working as not working out any mutual assessment period. Other times they've worked as a locum, or other times they don't need a mutual assessment period. It's just mutually agreed that's not necessary. Also, do check on your PCN schedules and make sure they're up to date. I'll show you where you sit in the landscape of PCNs and other commissioners in a moment. So that's what partnership means. Partnership in GP land is liable down to the sole of your shoe. Now, forgive me if you know some of this already, but I just want to, I'll pause after this just to take any questions that may have cropped up in your minds. But this is where you're sitting in GP land. So you are very firmly on the provider side. You may be sitting up in due course with a GP lead up at the ICB, for instance, or indeed be working for the LMC. But the blue oval is where the GP practice partnership is sitting in the landscape of everything else that's going on. And you can see there's a very clear, and always has been, a very clear commissioner and provider split. Now, drilling down into that blue oval, you can see that now, since 2003, non-clinical partners have been able to contract via the GMS contract with the government via the ICB, as they currently are constituted. So a practice, a GP practice, can comprise, it's got to have at least one GP in it, but it can comprise of GPs and non-GPs. And that new to partnership scheme that came through listed out a whole load of other people that can contract as partnerships: clinical pharmacists, dietitians, etc. And non-clinical business managers obviously have been around for a very long time now as partners. So I'm just going to work around this oval to show you these yellow boxes as we work round. I hope you're able to identify them as what I would call filing cabinets. So at your end, you should be able to electronically locate each of these documents that I'm going to start working my way through. So the partnership deed is one, and you should have a filing cabinet in someone's office, maybe your practice manager or business manager's office, and you should be able to locate all of these documents. And if you're joining, you should be asking for these documents. So you should understand what's in the partnership agreement, and any offer letter should refer to it. And you absolutely should know what kind of contract or contracts, if the practice is holding multiple APMS, PMS, GMS, etc., contracts are owned by the practice. It always surprises me when I ask, are you GMS, PMS, what are you? Oh, actually, let me go back to the drawing board, I'm not sure. You should know what kind of contract you've got, because it's completely fundamental to the way you contract. What kind of property is there? If there's freehold and it's of a sufficient value, and maybe there's a subset of non-property owning partners, you may want to have a deck of trust in place, a declaration of trust. I'll come on to that in more detail later in the presentation. And has the partnership got leases or indeed licenses or tenancies at will? Employment contracts, are they all up to date? Handbooks, etc. Data protection policies, privacy policies, have you got all that in place? And then obviously you'll be part of a PCN and you may or may not be part of a federation. Where are those documents and are they up to date and robust? So all those yellow boxes, I'll come back to them during the course of the next 40 minutes, are what you should be looking at when you join a practice, or if you are indeed running one, where are those documents? Now, I'll just pause. Is there anyone that's got any questions so far before I move on to the confusion abounding in GP land around the names of different people and what they mean, because there's a huge amount of overlap? So what I'm going to do is actually compare salary GPs to locums and partners, because I'll demonstrate how the overlap can cause huge confusion. And whilst you might be calling Daphne a partner, I might actually be something completely different. So let's get this clear. The law in this country only recognises 3 types of workers. And in the area in which you work, we're talking about a self-employed partner, be that a GP or another allied health professional or a non-clinical partner, an employee on the payroll, which sounds obvious but isn't always because of the roles they often take, and then an independent self-employed contractor, which in your world is usually a locum. Only 3 types of workers. The joint and several liability partnership model that you work under, most GPs work under, GP practices work under, is governed by the 1890 Partnership Act. It's a very, very old statute, and over the years we've been involved as a firm with trying to see whether or not it can be updated with the Department of Health, and there's been various working parties invoked, and it's never really got very far, because actually it's quite a short, succinct 7-page A4 statute, which is very brief, but in being really brief, it's actually rather good. Now, it doesn't contain various things like maternity leave, parental leave, because the Victorians didn't have any of that in place when it was drawn up in 1890. And that is why, because it's so brief, you have a contract called a partnership agreement or a partnership deed. A partnership deed and a partnership agreement are the same document. It's just a different name for the same document. But the partnership agreement carves you out of certain things that you do not want in the statute, and that is why it is such an important document. But if you don't have a partnership agreement in place at all, or you've got some ropey old document that was drafted in the 1970s and it's just got many, many deeds of addendum attached to it, then you are heavily reliant on the Partnership Act 1890. And the Partnership Act 1890 says some of the things that I've said here. It makes it clear that you are carrying on business in common with a view of profit. That's what it means to be a partner, whether or not you've got a partnership agreement in place or not. You're participating in the management. You're sharing in the profits and the losses, so you've got risk. And you're contributing to capital, which usually in your world is 2 things. That's working capital, which is usually a small amount for teas, coffees, drugs, dressings, vaccines, etc. So there's working capital, and the only other type of capital usually in a GP practice is building capital, if you're buying into the building, which is usually a freehold or a long leasehold building. So it's very, very brief, and you can see how you can accidentally become a partner. So the Victorians didn't believe in any mutual assessment period, for instance. So if you join a practice and everyone says, well, actually, we're a bit cost constrained, Daphne, you're on a mutual assessment period, but we'll wait until that's served out and then we'll put a partnership deed in place. Absolute disaster, because that means you're falling back on the 1890 Act, and that says that you share profits and losses equally from day one. There is no mutual assessment period. It doesn't matter that I'm working part-time on 3 sessions a week. I'm still on an equal share with those partners that are working 8 sessions a week. That's why you need a partnership agreement in place from day one. So coming back to remember the different types of workers, partner or employee, it caused me a couple of years back, and I continue to refine it, to draw up this table, because the definition of a partner is very, very brief under the 1890 Act. The definition of an employee, there isn't one. It's all driven by case law. So what it did is cause me to draw up this table, because if you find yourself more on the right-hand side than the left-hand side of this table, the chances are that case law, if your position was challenged, or you chose to challenge your position yourself for various reasons, the chances are that you'd find yourself defined as an employee more than a self-employed partner. It's all determined by case law. So I'm going to give you a real live example now, where I hope you can see the overlap, which is that, and I'm going to use myself as an example rather than the people concerned, because I've seen this happen so many times over the course of 30 years that I've been advising GP practices. I join your practice as a fixed share locum on a 1-year contract to cover maternity leave. I'm really good. The person doesn't come back from maternity leave, so I stay on. The original fixed term contract was documented. The second year's fixed term contract is documented because you want to just update the original fixed term for 1 year. I'm not sure if I want to stay on as a locum. You're not sure whether you can afford me or whether you're going to staff the surgery in a different way. So for 2 years, I'm on 2 fixed term 1-year contracts. I'm really, really good. And actually, you decide you're going to keep me on as a locum. I'm quite happy working as a locum. I don't want to become a partner just yet. I might have verbally said that. I've never written it down. We've just had informal conversations. I'm not put on the payroll. And that continues that arrangement, that very fluid arrangement. I turn up to the surgery. I work under your direction. And I do that for another 10 years. I'm really, really good at my job, and it suits me to do that. I'm so good that actually you start to ask me to attend interviews for new employees at the practice, and you ask me to stand in on some partnership interviews because I know the business inside out. I attend interviews and I give my view on whether people should be recruited or not as an employee and indeed as partners. Can you see how my position has morphed? And what am I? What's my status? Am I actually a self-employed contractor working as a locum? Or am I an employee? I was actually so good 1 year, I needed to go over to the other side of the world to deal with a bereavement for 6 weeks. And you said as a reward for that, I could be paid. I could be paid holiday leave. Can you see how my role has morphed? Maybe I'm an employee with statutory employee rights, or maybe, and in the alternative, if I'm not an employee, I am maybe a partner at the practice entitled to a share of the practice profits. We have seen that confusion happen so many times over the years. And what happens if you do not document that those arrangements properly, it's just a cost of doing business. And I know that GP practices are cost constrained, but the cost of resolving those sorts of disputes are expensive, and the cost of just documenting them properly are not, relatively speaking. Because otherwise you can give people statutory employment rights or give them rights that they can raise against the business which you hadn't expected and hadn't anticipated. So if you think you are sitting on one side of this table as opposed to another, you need to get the relationship properly documented, otherwise you're going to have problems. In terms of turning to the types of partner and away from the independent contractor and the employee, obviously, these are the types of partners. Again, it's not defined at law, but this is what you see in GP land. I'm going to focus on the top three because that's where the confusion abounds. Partner by holding out is basically if I've left and you don't take me off the website, if I want to bring a third-party claim against the business, I'm looking for the deepest pockets possible. So I'll include anyone and anyone that I can. And if I'm named on the practice website or the practice letterhead or the sign outside the surgery and I've left, I'm a partner by holding out. If I am a salaried partner, which is an employee, I'll come on to that in a minute, but I haven't had my role properly distinguished from the equity partners, I could also be a partner by holding out. Sleeping partner is basically someone staying in the business as a non-working partner, usually in your GP land, because they own a valuable freehold building or a long leasehold building, and the tax implications of that building leaving the partnership as a partnership asset are such prohibitively expensive that they need to stay on as a sleeping partner until the others can afford to buy them out. It's quite a rare position, which is why I don't really want to go into any detail in it now. But if anyone's got that position and want to raise it with me outside of this presentation, they're very welcome to do so via the LMC. So I'm going to focus on those first three. Now, equity partner or parity partner will probably be very familiar to you. It's a partner that's entitled to a share of the profits, and with that risk goes a share of the losses, which actually, let's be frank, there aren't that many GP practices that go under. I mean, I came across one last month. It's very rare for GP partners to be declared individually bankrupt. They've usually had lots of warning from the accountant before that happens and have ignored it and just continue to overdraw. But it does happen, and it also happens with non-clinical partners too, and non-GP parity or equity partners, but it's rare. So because there is also lots of other insurances around. If you're sued as a practice, you've got the state-backed indemnity scheme for clinical work, clinical negligence, and you've got all the plethora of your business insurances around you: employers liability insurance, buildings insurance, etc. The risk in a GP practice, I would argue, is relatively low, unless you don't get yourself properly structured and the business documents in place. But you do have full joint and several liability status. So you're down to you're liable for the debts and liabilities of the practice down to the sole of your shoe. It is possible to incorporate a GP practice. It's always been possible since 2003. We're seeing a wave now of GP practices incorporating. It needs CQC and pensions approval. So before you TUPE the staff in, and it takes about 9 months to get from being a partnership to a limited liability company. It's a very different beast, and it's not always the solution for everyone. So if that's something that you want to go down, I think we'll do another presentation with the LMC about what that means and how it's achieved. So that's the the model that you'll be most familiar with, the equity or parity partner. And you see this concept of lockstep to parity, depending on how hard it is to recruit a partner, how much trust you've got in them, and how experienced they are. So the partnership deed will document that lockstep, that 75 to 80% to 90% to full 100% parity share. A fixed share partner takes a fixed share of the practice profits. Now, that's usually, they have to have an element of variable income, and it's usually a discussion you've had with the accountant about what that fixed share of the practice profits is. It's got to be in the partnership deed set out that if they've got a fixed share of the practice profits, then they must have a fixed share of the practice losses. I've seen so many partnership deeds drawn up by lawyers who have documented the fixed share for the individual, but have not ring-fenced the liabilities, and that's a very unhappy position. I would feel very uncomfortable being on a fixed share of the practice profits and then have joint and several liability for all the losses. So that's easily overcome with good drafting. They may or may not have limited or full voting rights. Quite often, they usually have full voting rights, because if you're in a joint and several liability business, you want some vote and say over the direction of travel of the business. So I think it would be unusual in your GP land to have limited voting rights, but it's something that needs to be addressed in the deed. Sometimes you see a carve out if you're a non-clinical partner that you have no vote on clinical matters, and those clinical matters are set out. Now, let's come on to salaried partner. If you notice, the previous slide said fixed share, because an equity partner and a fixed share partner take a share of the practice profits, and they share in the losses. Note the title of this individual. They're on a salary. They are not a self-employed partner. They're on a salary, they are an employee, and the title says everything. And I've lost count of the number of times that I've seen lawyers and practices misnaming people, calling people salaried partners and having them in the partnership agreement. It's absolutely not right. A salaried partner is an employee on the practice payroll, and they have a salaried partner, an employment contract where they're given a title. It's just a title that they've got. They may have some whistles and bells around their appointment, so they may have additional holiday leave or a little bit of extra pay, or they may get a bonus based on the practice performance. That is not, I've seen salaried partners getting a share based on the performance of the practice. Absolutely not. Employees get a bonus, and that should be written into the employment contract. It's very, very important that you make sure, if you've got a salaried partner, that they have an employment contract and they are not a party to the partnership agreement. Oh, I'm not sure why my slide deck's sticking. There we go. And they have absolutely no voting rights. So that example that I gave you of the locum that came in and for many, many years was starting to take part in management meetings and make management recommendations, that same individual actually ended up voting on whether people should join the business, and ended up picking up risk at the end of the day. So be very, very careful. If you are a salaried partner, you should be having no vote. You can attend management meetings, and many salaried partners do this. But if you give a view on what you think, make it absolutely clear that it is a view only and you are not voting on any decision, and your decision might have some influence, but ultimately the owners of the business need to be making the decision. Does anyone have any questions, or shall I move on to the traps and minimizing risk on partnership agreements? I'll take it there's nothing in the chat, is there, Rima? Okay. So I've mentioned before already that if you don't have a partnership deed, the position is that you're a partnership at will. But I would be really careful about that. I mean, I'm rather long in the tooth, but I quite often get a phone call saying, I'm a partnership at will. We are a partnership at will. So it's not actually that simple, because actually, even if a deed was drafted in the 1970s, if you've all been looking at it and you've been abiding by it and you've been having meetings in accordance with it, it may well be that bits and pieces of it are actually binding. So it's not straightforward. I wish it was black and white, but it isn't. But anyway, the position under the Partnership Act 1890 is that if you do not have a partnership agreement, you are a partnership at will. That is an incredibly unstable position to be in general practice nowadays, because of a court case last year called BART. And I don't know whether at BHAT. It was in 2024 last summer. And what happened there was that the doctors didn't have a partnership agreement. And it was a majority against a minority. And if you're a partnership at will, you can dissolve and reform without an individual. They lose their livelihood. And what happened there was that the NHS contract just got varied into the names of the people that were continuing, and they demonstrated that they continued with the GMS delivery, and the ICB said that was fine. It went all the way up to the High Court. That means if you do not have a partnership agreement in place, it is possible, you've got to get the position properly analysed by a healthcare solicitor, it is possible to dissolve and reform without an individual or without individuals. It's more the case without an individual. And that leaves the business very unstable. So you must have a partnership agreement. If ever there was an argument to have a partnership deed in place, it was the court case of BART last year. It's very, very rare that a general practice gets into the High Court. I have no idea how much that court case cost. Even to lodge a High Court claim these days is 10,000 plus VAT starting. So given there is no goodwill in a general medical practice, it is so rare that court cases get up that high. But that is one of them. We weren't involved in that, but it's something that you need to be aware of. I was saying that you need to be careful about, I am a partnership at will, because of all the other written evidence around it. It may well be you've got offer letters around, you've got partnership, old partnership deed, partnership minutes, partnership accounts, but they are not definitive. So the position needs analysing. These are the sorts of things that I would expect to see in a well-drafted partnership deed. I'm not going to go through all of these, but I'm just going to focus on a couple of them. The first one is the last partner standing clause, which is the 5th bullet point up from the bottom. This was something that was a recommendation of the BMA a few years back now, but as particularly for those partnerships that find themselves with various debts and liabilities, they may have a very expensive surgery building, where there is a struggle now because of buildings being overvalued and bank valuations not matching notional rent payments to service the mortgage debt, or practices in CHP or NHSPS leased buildings where there is no lease but high service charge debt demands. It may well be that you find that the liabilities are higher than you thought. And so you want to ring fence those liabilities, But also what you find is that there is a diminishing number of partners. So I can think of many practices now where there used to be 20 partners plus and are now down to 12 or 10. I can think of many practices that were 10 partners plus that are now down to 5 and are looking at 3. Where you find that position happening, you really do need a last partner standing clause in your deed. And people ask, well, what does that mean? It means if I'm in your practice and I can see a big dilapidations debt coming in where the roof needs repairing and we haven't kept a sinking fund going, and that's something that I don't really want to pay for, it may well be that I quickly hand my notice in. And so what you need is to be saying, if Daphne hands her notice in, I mean, I'm just going to describe the way ours works. If I hand my notice in, it gives an opportunity for the remaining partners in the business to think, right, Daphne's handed her notice in. Do we have a viable business without Daphne that we can afford to run? Can we afford to buy her out? And can we afford to carry on? Because we've got various salary GPs that are chomping at the bit to become partners. We can advertise and we can really easily fill Daphne's place. Actually, we're really glad Daphne's going because she wasn't performing well anyway. So good riddance. So the question on a last partner standing clause is, do you have a viable business without the person that's handed their notice in? If the answer to that is yes, excellent. Daphne's notice, handed in, and I work my notice out. If actually Daphne leaving gives us a business problem, then we have a period within which to think, have we got a viable business or not? And if we haven't, what are we going to do about it? Are we going to want a longer period of time to buy Daphne out because we thought everything was honky-dory and we said that 12 months we could buy Daphne out over a 12-month period? Sometimes these deeds are drawn up with a 6-month period. That definitely is far too short. Do we want to buy Daphne out over a 24-month period or longer, in which case that needs negotiating? Or do we have a bigger problem because it's not just about us, and maybe we need to think about disposal to a third party or merger within our PCN? An absolute last resort is Daphne was so critical to the business that actually her leaving means we've got to hand our contract back into the ICB. That is an absolute last resort, and you should be completely speaking with your LMC before you ever get to that. There are always many other solutions before you hand your contract back in, because if you've got a vulnerable list size, which can't always be dispersed, you do not always get rid of all the liabilities that you think you are resolving by handing your contract in. So that's what a last partner standing clause does, and it's a really important clause to have in. The other clause to have in is to avoid this business, like Bart last summer, of going to the High Court. Bottom bullet here talks about arbitration or the courts. 99.9% of GP partnership agreements, whether they include a non-clinical partner or not, have an arbitration clause in them and not the ability to go to the High Court. Because the ability to go to the High Court can cost hundreds of thousands of pounds. An arbitration gets you privacy. Remember, I can go onto the High Court listing and I'm a nosy person. I can see every court case that's listed. I can turn up at the High Court and listen in on what those GP practices are arguing over. Patients as well. That's not a good thing. Arbitration, the costs wise, I mean, it's so rare that this happens, but if it ever does, the threat of going to arbitration is a real tool to actually resolve a dispute. And you can choose your arbitrator. You know, I can get, if it's an argument over the value of the building, I can get a healthcare surveyor appointed to be my arbitrator, and I can get that valuation sorted out within a matter of weeks. I am not stuck with a High Court case, which could take 2 years to get a listing, with a High Court judge that might be free of charge, but has absolutely no idea how to value a GP surgery building. If it's an argument over the GP accounts and how they've been drawn up, I can get a healthcare accountant appointed as the arbitrator. It's all secret. No one needs to know about it. And I can get that organised within a matter of weeks. So always, in my view, an arbitration clause, not the high courts, but remembering that it's so rare to get that far, and any partnership deed should have a proper dispute resolution process in place, which you absolutely stick to. And that means you've got a period of negotiation between yourselves, and then usually, with the help of the LMC, a bit of further negotiation stroke mediation, maybe with the help of a lawyer at that stage, to close the issues down really fast so they don't fester and escalate up to a more formal mediation and arbitration. So these are the practicalities. I've just talked about the absence of documentation, and I know you're so busy, which is why all this documentation gets overlooked. But just make sure you've got a formal offer letter, which is then replaced with a formal partnership agreement, and then all the other practicalities around that, which I don't need to go into today. And make sure, if you've gone to all the effort of getting a partnership deed drafted, you sign it correctly, you date it correctly, and you stick rigidly to it. Don't start, as I've heard so many practices over the years, saying, well, we thought we were being nice to Daphne. We changed it so that actually, you know, we changed the sick leave period so that, you know, she didn't have to pay for her absence cover after 3 months. We thought we were being nice. Well, where was that documented? Oh, it wasn't. Be very, very careful that you stick to it. If you're going to change it, take advice and properly document any change. So I just want to end up today, and then I'll take questions after this section, on surgery buildings, because I think they are so often overlooked. Remember, I talked about the direction of travel being scale and integration. And I was talking to a practice yesterday, you know, that's now running over 6 sites, and it's a bit confusing about how the buildings are owned, and actually what kind of practice they are. Are they a centralized super partnership with one partnership agreement? That's not how some of them view themselves. Or are they what I would call a decentralized super partnership, where they've got an umbrella partnership agreement, almost corporate style structure sitting up here, and then each of the six GP practices underneath that umbrella is effectively operating their own branch site and reporting in. The GP practices that are all thinking they might just be branches want both, because it suits them to be both. They want to be centralized and decentralized. And I was saying to them, well, you can't have it both ways. You better get that sorted, because you're heading for a dispute, because they've now identified target practice number 7, and some GP practices are saying we want to be named on the GMS contract, but we don't want any profit risks associated with that practice, because number 7 is a failing practice. And others are willing to take the risk, but they want everybody else to go onto the GMS contract just in case the deal doesn't work out well. Well, you can see there's risks abounding, and it needs properly documenting. So, GP surgery issues. I'll touch on freeholds, and then I'll come on to leaseholds, because obviously there's both types of buildings in GP practices. I've seen various lawyers sending out partnership questionnaires which say, do you own the surgery as a partnership asset? And I've seen practices innocently answering that with, we own the building. What should be, and that causes enormous problems, and I'll explain why in a minute. There should be 2 questions. Who owns the building? And separately, is the building owned as a partnership asset, or is it owned as an investment asset? And that is so important in GP land, because when you, regardless of who owns the building legally, If you own the building as a partnership asset, the building is owned by all the partners, whether they are property owning partners or not, beneficially. So the legal title at the land registry may say one thing, but actually the reality is, what does the partnership deed say? And I have seen so many partnership deeds where the lawyer has misunderstood the position and actually carved the building out of being a partnership asset, because they've said, Dr. X and Miss Y and Ms. Y own the building, but they haven't documented the building as a partnership asset because the lawyer hasn't understood what it means. 99.9% of surgery buildings are owned as partnership assets because of the tax consequences and the tax advantages at the moment of owning a freehold or a long leasehold surgery as a partnership asset. By which I mean, when you convey a surgery between partners, clinical or non-clinical, there's no stamp duty land tax. And when you convey between partners, there are tax advantages for capital gains tax. On current rules, you pay 2/3 capital gains tax, and there are inheritance tax advantages alongside, speak to your accountant, other tax advantages. That's why most surgery buildings are partnership assets, and they are owned as such, and they are financed as such. So the bank usually finances the building on preferential interest rates as a partnership asset. And the moment that building is an investment asset, it needs to be refinanced. So when you put a lease in place, you are effectively taking a building out of the partnership as a partnership asset, putting a lease in place, and if it's financed, it needs refinancing as an investment asset. Because the moment the lease is in place, de facto, the freehold or long leasehold surgery cannot be a partnership asset. The partnership asset is the lease. And what you see in general practice now are surgery ownership moving around. Now, it may be that it has completely left the partnership. You see this quite often. The notional rent continues to come in through the GMS, and then the practice manager or business manager just pays the notional rent out to the former partners, and nothing is documented around the occupation of that site. In that situation, the surgery has wholly left the partnership because no one in the partnership owns the building. What's happened is that those partners occupying the building are gaining some incredibly valuable squatting tenants' rights. And that's why it's such a dangerous position to leave the practice in. It may be that the building has partially left the partnership. So it may well be that you've got a practice of 5 partners, for instance, 3 of which own the building, 2 don't. Maybe they can't afford to buy in just yet, or they never want to buy in. And it may be that those 3 owners own it with 2 that left a couple of years ago. And one of those that left a couple of years ago has died. So actually, it's the estate of that former deceased partner that owns the building. Can you see? All of this needs properly documenting, because you can end up in a total muddle if you haven't set out what happens. We do see limited companies now owning buildings, particularly when they are of there's tax advantages to doing sale and leasebacks, particularly if the sellers and the tenants on the lease are the same. It's possible to put the property into a separate property owning company. Again, that's a conversation for another day. And then sinking funds, you need to take tax advice. If you are not putting a sinking fund in place to deal with the way the building is going to be maintained, that's usually set out in a property owning document called a declaration of trust deed. Remember those yellow filing cabinets I talked to you about at the beginning of this presentation? One of those was a declaration of trust. If you don't want to put in a sinking fund, that's money that you pay into every year, so that when asbestosis is discovered on the building and needs stripping out, or the roof needs replacing, or the windows fall out with a hurricane, If you don't have a sinking fund in place, which many accountants advise is not very tax efficient, you need to have the potential repairs and everything. You need a surveyor to come in every time you have a property owner leaving or someone joining. What's the cost of likely costs of repair, and keep those continually up to date so you don't end up with some massive bill that's underfunded. Check closely what are the rules on buy-ins and buyouts. We just this morning sent out an open letter and without prejudice letter to a well-known firm of solicitors who are claiming in the alternative that it's 2 surgery buildings worth collectively about 2.5 million. And they are saying in the alternative, if you let our clients buy the building as a surgery partnership asset, we'll pay one value. If you don't agree to that value, on the drafting of the partnership deed, we're paying you half that sum. And by the way, also, we're going to let the bank know that they can foreclose on the building. Very unpleasant position for the client that we're acting for. A very, very badly drafted deed, which left the client in a very vulnerable position. So you always stick rigidly to the terms of the partnership deed, and you cannot have it both ways. You cannot argue in the alternative that a building is a partnership asset or not a partnership asset. It either is or it is not. So I think I've said enough about declarations of trust, other than to say be careful with deeds that say you have options in them to buy people out, because if there are options, when do you serve those options and what do those options say? I find those options are very often overlooked, and if there are timescales for serving options, make sure they are set out in the partnership deed or the declaration of trust deed. Leasehold surgeries, for those in leaseholds, and I'm not talking about long leaseholds, I'm talking about short leases of 25 years or length with PHP, NHSPS, or a private landlord. The district valuer now for private landlords, not with CHP or NHSPS or Assura or one of those, Assura selling up, aren't they? So they won't be around much longer, but the district valuer on any private landlord lease, by which I mean retired GPs or others, is usually won't approve a lease of more than 10 or 15 years in length. But you need to make sure, is that lease in current names? If Daphne has left the practice, I need to come off that lease. I should be insisting I come off that lease as a retired partner, because I don't want to be responsible for the rent, because if I'm left on that lease, I'm responsible for all the obligations to the landlord, including the lease rent, because I'm named on it. I'm contractually obliged to the landlord to observe the lease covenants. Now, if I'm no longer a partner in the practice, I'm not getting any rent reimbursement through the GMS contract or PMS contract. So I've got no way of servicing the lease rent. So I should be insisting that I'm coming off it, and the practice should be making sure I come off it. Because if I die or become incapacitated or disappear off and become uncontactable, getting me off that lease can become really problematic later on. As people leave, they should come off the lease, and as people join, they should go onto the lease. I know there are firms out there that say you can only have 4 people named as the legal leaseholders at the land registry. And so if you're more than 4 partners, only 4 partners' names go on as named tenant on the lease. Personally, if I was in a practice with 4 or more partners, who should go onto the lease then? And you find people are advised, well, it's the top 4 senior people. It's the bottom most junior people because they're less likely to leave. It's the middle 4. Why should it be some and not others? Because if there's a breach of the lease, only those partners that are named on the lease are liable, and you are wholly responsible for the lease covenants and wholly reliable on some indemnity written into the partnership deed to draw the other partners into those lease covenants. And if you haven't updated your deed, or you've let the indemnities lapse for whatever reason, you're going to end up counterclaiming. Personally, I wouldn't want to be in that position. If I was in a practice of 4 or more, everyone should be named on the lease, and then you've got absolute transparency and equanimity in front of the landlord. Everyone's on the hook. And some don't have more risk than other partners that have less risk. And business managers and practice managers, I've just put some aid memoirs there on make sure you understand some of the key clauses in these leases. Where is your lease report? Diarise this important break date. We had a practice that had a September break date. They missed it, and they were on the hook for another 4 years of rent, even though they were moving out of the site into a new development. That did get resolved, but it involved some negotiation. So make sure you diarise those key dates. Partnership disputes, I'm running out of time, so I won't keep you much longer, and I know some of you may have to leave. Please make sure you follow the signed documentation. I think the big thing with partnership disputes, I see, if you take any message away from me on partnership disputes, is that I see them going on for far too long before the appropriate professionals are involved. By which I mean, in GP land, people are generally speaking conflict averse. You are busy professionals, and you tend to tolerate poor behaviour far more than I would ever see outside the National Health Service. Last week, a partnership putting up with intolerable behaviour for 3 years before they even picked up the telephone to the local medical committee. And before the local medical committee said, you know what, this is just so deeply entrenched, you need some support from, you need some legal assistance. That problem can get resolved really, really fast, actually, because the general practice didn't realise their negotiating leverage. But had they taken advice 3 years ago, it could have got resolved 3 years ago. In the meantime, what's happened is that staff have left, staff have brought grievances, partners have come and gone. And the existing partnership are feeling so worn out over it that actually it was the very small thing that caused them to pick up the telephone to the LMC in that instance. It was the person being late, when actually they've been late for 3 years. They turned up 10 minutes late for a surgery. And that was the thing that caused them to pick the phone up, because enough was enough. I'm not saying that, you know, if Daphne turns up 10 minutes late for the first surgery, you immediately go running off to the LMC or a lawyer for assistance. Of course not. You don't leave something festering for 3 years. I've seen it with staff as well. Don't leave things festering. If you identify you've got a business problem, the LMC are there to help you, and the LMC will let you know if it's something that they need further support with or think you need further support with. But these things, the longer they fester, generally speaking, the worse they get, and morale can deteriorate very, very quickly. But I understand what happens because you're busy. Be really careful with managing DSARs. We're looking at a medical institution now that's managing 2 DSARs with 250,000 potentially disclosable documents. You know, you've got to be so careful with what you redact and what you disclose. You don't have to disclose everything. I think there's a tendency to think, I've got to disclose 250,000 documents. That needs an AI bot on top of it, and it needs some careful thought about how to manage that, along with key deadlines being diarised. So act early. I'm going to stop sharing now.
Yes.
Yeah.
And
Yeah, I've just got it.
Okay, Alexis.
I was somebody accidentally with their mic on, Daphne. Sorry
That's
about
right.
that.
I'll stop and then just open up the forum, Rima, to you and any other questions anyone may have, because I'm conscious we've slightly overrun.
I mean, it was a very comprehensive discussion. Thank you, Daphne. Has anybody got any questions at all that they want answering? Pop your hand up. I'm more than happy to bring you in. Oh, we've got a question in the chat from Safwan. Safwan, did you want to unmute and speak to us, or do you just want me to read it? Just read it. I've been working as a locum GP.
Read it. It's just
a
simple enough question Daphne might know a little bit about, because I work as a locum. I've worked as a locum for a long time, and it's similar to what you said. I work in places and then you just end up becoming part of the furniture. But since IL35, you know, there's been a big scaremongering around practices actually hiring locums because they're worried they're going to get stung. And what tends to happen is that if you want the job, you have to sign this paperwork saying that if IL35 come after them, the doctor is going to be fully liable. Otherwise, you won't get the job anymore. Have you had any experiences with some partners that have been stung by the IL35, or any practices that have been stung? Or is it just a threat from the HMRC that really doesn't become fruitful for them?
Yeah, I know it's a risk. And you know what? It comes back to robust documentation being in place that you can, if the practice is investigated or you personally are asked the question, you know, how are you working through your own personal services company, PSC? How's that accounted for, and what's the relationship? Making sure that you minimize the risk that there is any IR35 problem. We're well aware of it. It comes back to proper drafting being in place.
So have you known of any surgeries that have been fined?
I am not aware of any, but I might not necessarily know about it, either because they hadn't told me, or because it may well have gone to the accountant rather than a law firm.
Oh, that's fine. Thank you very much for the answer.
I do think it's a good question to have raised, though, because I am surprised HMRC seem to be sitting back, and I think maybe this will get edited out, Rima, of the recording, but I've not seen, you know, for instance, surgery buildings leaving partnership assets triggers an immediate potential stamp duty land tax charge to the partnership. And if HMRC wanted to, they could have a good old look at general practice. And I am not aware that they have done so, or are indeed planning to do so. I think maybe they realise that that would be politically very, very difficult and unpopular.
Thank you for your answer.
Halal's just popped in the chat that actually a really lovely presentation. Maybe it would be useful to have one on how practices can incorporate, because it is now happening, I guess, a lot more often.
It is. It is. It's interesting, actually. You know, if the LMC had asked me a year ago to do something like that, I would have said, you know what? I mean, if I just so you've got some context and perspective, we act for about 3,000 plus GP practices nationally. Of those, the last time I took a straw poll, you know, we'd been involved in the incorporation maybe of about 70. Now, that's not all the GP practices that have incorporated, because if you go on Companies House, you can find out it's possible to have a look and do more due diligence around that. It's been a bit of a slow burn. I think for two reasons. Number one, I don't think all GP practices realised they could incorporate. It was news to them. It's not always the solution for all general practices, because it all comes down to need, the practice setup, what you're trying to achieve through GP practice incorporation and becoming a partnership limited by companies, becoming a company limited by shares as opposed to a joint and several liability partnership. You've got to get pensions and CQC registered. It's actually not difficult. As long as they keep on changing the forms. There's a suite of forms you have to fill in. I think it's absolutely right, though. I've noticed a real increase in the amount of interest around it, because I think there's just a general curiosity of having a different business model, particularly with the scale of general practice. It's not always the right solution, but I absolutely think we can do something with the LMC on it, and would be delighted to do so.
Perfect. So I think Charlotte Mirror will sort of work that up as another potential option. Any other questions at all? No, I think that's probably it. Just a quick reminder that we've got some other LMC events coming up on the 30th of July. We've got the Notional Rents Review and Improving Property webinar. And we've also got is the MHRA? Yes, on Friday the 18th of July, 1 till 2 as well. We've got the LMC online seminar with CQCs on MHRA. So, but thank you so much for your time, Daphne Robertson. We really, really appreciate it. And I think that's shown by everybody in the comments.
Thank you so much, everyone.
Brilliant.
And thank you, Rima and Charlotte.
Thanks. Bye-bye.